Court on order.
All right, good afternoon, ladies and gentlemen. Please be seated. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. 22 SC 183572. I see Mr. Stillwell, Mr. Boston, Mr. Shark. Good afternoon, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams. Who's that man that doesn't look like he shaves? That's sitting next to you, Mr. Adams.
Your Honor.
Oh, you were going to get to it. Okay. I noticed him immediately. So.
And you actually met him before. This is Graham, B-R-A-M, Mansbach, which is M-A-N-S-B-A-C-H.
One more time for the first name.
Yes, Graham.
Graham?
No, B as in Barry.
Bravo. Bran?
E-R-A-M as in Matt.
Bram. Okay. All right. Last name again?
M-A-N-S-B-A-C-H. And he just graduated from Hamilton College. He's going to be going to law school, not this August, but the following. And I have the honor of working with him in the interim. And he's going to be before your court. With the court's permission, I already asked the sheriff here for permission, and he is here today, and I expect he'll be here a great deal.
So are you getting rid of Ms. Halterwinger or what? There's that one assistant rule. So, you're going to have to either have physical challenge or something.
We have a physical challenge because they have me. So. But anyway.
Okay. All right. Yes, it's fine, sir. It's fine. It's fine. Sir, welcome. Hope you this will facilitate your soon-to-be legal education, all right? Okay, welcome. All right, Mr. Kendrick and Mr. App, good afternoon. All right, Mr. Huey and Mr. Matthews Jr., good afternoon. Mr. Nichols and it's Mr. Westmoreland. Welcome back. Good afternoon. And then Mr. Ryan and Misty Williams, good afternoon. All right. Mr. Uhelski, Ms. Lowe, Ms. Knight, and Mr. Smith, good afternoon. All right, okay. Sergeant Ingham, all jurors present.
Yes, sir.
All right. Anything you take up before we call out our jurors? All right.
Your Honor, sorry. Just a suggestion. I think before Sammy Davis testifies, there's multiple legal issues, discussions that he.
I don't think there are. I read the order, and I'm good with the state's not going to seek any out of court identification. Whether or not they seek an in-court identification, I said I would take that up if that were the case. I don't know whether or not they're going to do that, but my order is pretty clear about what I ruled upon.
I agree, Your Honor. The only thing I'm saying is I would hope the state would give notice that they intend to seek an in-court identification, but then you would have to analyze that as far as individual origin. There is one in my.
Or remember, I didn't rule upon that because that wasn't before me. You haven't filed anything, and there's nothing for me to consider at this point in time.
Well, Your Honor, I did in the initial motion, but he wasn't here to testify, so we didn't address the independent origin. And it was speculative whether he'd be making an in-court identification. All I'm seeking to avoid, Your Honor, is if there is going to be an attempt for an in-court identification, I don't believe it will be.
Let's find out. Are you going to try and do an in-court identification at all, madam?
At this point, Your Honor, we don't intend to. We've not shown Ms. Davis any recent photographs of either of the defendants.
Okay.
Mr. Davis says he recognizes somebody.
Well, that's another thing. Well, I can't postulate that for them, sir. Listen. There are pros and cons with any such attempt to do so, and I'll leave that for that time.
and Your Honor, all I'm going to say is that, and I have a bunch of cases, if the state is seeking to do so, the burden is on them to seek to show an independent origin outside the presence of the jury before that needs to be litigated.
Then you need to file a motion.
I have
We covered the out-of-court identification. Remember, I couldn't rule upon the in-court identification. So if you want to particularize that, you need to file it, okay?
The reason we didn't get to the in-court before was because he wasn't here.
Okay, but that's something you're gonna have to still posture, sir, okay? I mean, but at this point, I don't have anything before me. The state's told us that, or told you that, and all of us that they're not gonna seek an in-court identification. Now, there's nothing which says if he recognizes somebody in the courtroom that would not be, that wouldn't be proper. However, here's the other thing. You gotta lay a foundation for it, as well as there are pros and cons and risks with an in-court identification that goes bust. So, I'll leave it at this point in time. All right, and I'm going to include thank you for sending me the order, Mr. Short, and I am going to include it as the next course exhibit in order for the reminder, okay? All right, summon our jurors, please.
John, we have the, admission to
Oh, yes, this witness is not to be filmed because he has active undercover operations, okay? All right, summon our jurors, please.
Did you ever sign a screen? I saw an email from Ms. Hilton to the Honorable Court, CC to us.
What kind of?
She asked for a screen and you had concerns about it because, you know, we couldn't see, our clients couldn't see.
No, I don't. When was this sent?
Today.
Your Honor, that was for, in the event that our technology began backing up, what Ms. Hilton sent, I believe, was a request that we be allowed to replace the area that is now occupied with the easels with the mono board in the event that there are technical difficulties, and if there were, we would simply join Zoom through the Mondo board so that everyone is able to see what is on the Mondo board. At this point, we don't have the Mondo board in court now, so it's not an issue.
I think before you do that, when it is available, you should probably dry run it.
Yes.
See whether or not it will meet your needs and whether or not there are specific issues that need addressed, okay?
Yes.
So, Mr. Steele, I haven't dealt with it, okay? All right, summon our jurors, please, sir. All right, ladies and gentlemen, please be seated. All right, thank you, sir. Ingram. Ladies and gentlemen of the jury, good afternoon. All right, y'all sound good. Okay, keep that energy. I like that. All right, State, call your next witness. All right, some of the executive team. Detective Teague, good afternoon, sir. If you would please approach the witness stand. Once you get there, if you'd be so kind to turn and face Sergeant Ingram and be sworn as a witness, please.
Raise your right hand. You swear firm testimony to give the truth, whole truth, nothing but the truth.
I do.
Absolutely. State and spell your first and last name for the voice.
Sure. Hello, Detective Jason Teague, Jason, last name Teague.
Pull your camera on, please. Your camera. Thank you. All right.
Good afternoon, sir. How are you?
Fine.
Detective T, where do you work?
City of Atlanta Police Department.
And what do you do there?
I'm an electronic surveillance technician or / specialist in the Homeland Security Unit of the police department.
And how long have you worked with the APD and Homeland Security?
I've been a police officer for 26 years, in which I've been a detective for 20 years. I've been an electronic surveillance specialist since 2009.
Were you an electronic surveillance technician on January 10th, 2015?
Yes, I was.
And Detective, are you full certified?
Yes, I am.
Have you ever lost your full certification?
No.
Can you tell the jury what you do as a detective and an electronic surveillance technician?
Being a detective in the Homeland Security Unit, basically, the Homeland Security portion of it, we deal with everything from this critical infrastructure of the city. We deal with threats on threats on elected officials and things of that nature. And also we provide assistance for federal agencies for dignitary protection details, protectees, president, vice president, cabinet members, Supreme Court judges, whoever comes into town that's actually a protectee. But the electronic surveillance portion of it is, I specialize in basically surveillance means with electronics, everything from camera placement, covert and overt GPS tracking, body bugging, wiretapping, basically things of that nature.
Do you receive specialized training to become an electronic surveillance technician?
Yes, you.
What type?
You go to actually multiple schools. The basic class is just the basic introduction class to it is an 80-hour class that you take and you learn everything from dealing with electricity, dealing with circuits, dealing with capacitors, dealing with recording equipment, dealing with cameras, learning about lighting, basically everything you would need to do to work in the field and the basics. Then you start branching off in other specialties like installation in vehicles, which is a little bit different than installations in a room or a house. Then you go off in other specialties like learning about GPS trackers, placement of them, how the system works, different softwares. Then you go off into actually this portion of it, learning video recovery, dealing with different systems, learning the methodology, how you attack different video systems, how to recover the video, and how to make the video playable for detectives to basically look at all their evidence, and so it can be presented in court.
You went down fast.
Sorry.
And you briefly explain to the jury, not briefly, a little bit more. Explain to the jury what video recovery is.
Video recovery is basically you go into wherever there is a video system at, i.e. a DVR or NVR, which is a network video recorder, which is basically a digital video recorder on a larger scale. Digital video recorders, basically, to bring it down to layman's terms, is basically a system that records video from cameras at a location. And you have to learn the methodology about how the system works to actually recover video from it to basically play.
Can anyone do this?
Well, there are some people who have IT backgrounds and stuff like that who could go through the system and export the video, but there are some people who are just savants electronics, might be able to do it. Other people have to go to training. It's just like saying this is like, can anybody work on a car? Some people can, some people can't.
So, tell the jury the process, for like when you're at the school surveillance, what's that process like?
Process is basically a detective who's working the case will contact me or one of my partners. There's 3 of us to respond to a scene to actually pull video for them. Then once we get there, the detective will give us a date and time and what they need to see. Most of the time it's businesses. They'll tell us, I need the inside and outside cameras for this date and this time frame. And we pull video and time frame that they request, and we turn the video over to them to basically watch and study their video.
Approximately how many times have you been asked to, pull for their video?
Hundreds.
What agency have you surveilled the video?
Mostly it's for Atlanta PD, but I'll pull video from everybody from FBI, ATF, GBI, other agencies in Fulton County, College Park, East Point, South Fulton, and the DA's office.
Your unit, how many electronic surveillance technicians are in your unit?
3.
Do you and your team, or there's 2 others, go out and pull a video every time a crime is committed in the city of Atlanta?
No, we go out as we're requested because every crime in the city of Atlanta, there are a lot of them there's no video for. Happen in, wooded areas, out in different areas of the street or inside houses, there's no video for. So we're only requested when either one of 2 things. One is when businesses don't know how to give the detective the video. They might know how to play it, but they don't know how to export it and give it to us. Or 2, different things like people don't know where this is, or even how it works at all. That's when we're called in.
Do you ever work in an undercover capacity?
Yes, I do.
Me.
Well, pretty much daily, because we go out and we monitor different things as they pop up. Different protests, different incidents, or we go out to where the threats have been made, but also in the capacity when we pull video, we go out in undercover capacity because it puts the owners of the business at ease, because sometimes the owners they're in fear of retaliation for different incidents that might have happened on their property. So they're more at ease when they don't see a bunch of police officers showing up there to capture the video.
As an electronic surveillance technician, are you familiar with big cameras at all?
Yes, I am.
And how are you familiar with it?
Well, big cameras are basically the system that project between the police department and the police foundation, basically to expand video surveillance all over the city. And it's been an ongoing project for now. Really, ideas of it started way back in 2007, the ideas of it. But basically, it's integrating cameras throughout the city, City of Atlanta cameras that we own, private businesses cameras, different agency, county, state, federal agencies into basically our video integration center. Some people, you hear it in the news, they call it real-time crime centers and stuff like that, to monitor cameras to help alleviate and, catch criminals after they've committed crimes, or either to monitor crowds or large events, like the Super Bowl, the upcoming World Cup, things of that nature. You can remotely monitor larger areas. It's basically in law enforcement, it's considered like a force multiplier. So you can have eyes when you can put officers.
You mentioned it briefly, but what is Big Stand?
Video Integration Center.
And how long has the big unit been in existence with APD?
I think the VIC has been around APD since around about 2008, 2009.
And what is the big unit?
It's basically it's a centralized, basically crime information center where they can monitor cameras in real time, and actually they have a working map knowing where they have cameras with access to that they can watch recordings in the area to see if they can catch information about different crimes.
What are vid cameras?
Vid cameras are basically, to quickly sum it up, they're IP cameras, which are internet protocol cameras, basically that are placed on poles that are powered, that actually stream video to the video integration center or stream video to wherever the servers are for owners of the camera for the recordings of video.
Now, does the number of vid cameras, do they change from year to year?
Constantly. They're constantly increasing,
Are there more vid cameras in existence now than there was in 2015?
exponentially more.
Now, are you familiar with all the locations of the vid cameras?
No, you have to actually look in an interactive map to see where all of them are because it's constantly changing.
Each year, is the victim able to look at that integrated map and see where vid cameras are?
Yes,
Is the victim able to look at that integrated map and see which vid cameras are working?
yes, they can.
Is it routine for APD investigators to, ask you for vid camera footage?
No, usually they'll just contact the video integration center directly for vid camera footage.
Now, as an APD officer yourself, is it routine to ask a big unit for vid camera footage?
Yes,
Now, as an electronic surveillance technician, do you know what an LPR is?
yes, I do.
What is it?
It's a license plate reader camera.
And how do you know what it is?
Just years of training and basically dealing with them.
Is there a correlation between big cameras and LPR?
The correlation is basically they are information still piped through the video integration center.
What do LPR do?
They actually, in real time, take high-speed pictures of cars passing by, capturing the tag and running tag information.
Now, do you have any way of knowing where big cameras and LPRs are, even though they don't upload that footage?
Yeah, you have to look at the interactive map or contact the video integration center to see if there are any in the area of where your crime occurred.
Are electronic surveillance technicians always pull surveillance footage at time? Have they always pulled surveillance footage for APD?
Ever since we were basically formed to do that, yes.
And how did y'all come to pull in this case?
I was requested the location by Detective Thorpe.
Now, when asked to pull surveillance footage for a crime scene, do you ever tell or suggest to the lead detective on scene about surveillance footage that you have not been asked to pull?
No, like if the existence of like vid cameras in the area, if I knew about a specific vid camera, I would tell them, hey, there's a vid camera over here, a vid camera over there. Or even if I have a camera up in the area, I would let them know, but only if I know about it.
In 2014, have you previously pulled surveillance footage from the area of McDaniel, and Northside Drive?
Yes.
Have you pulled it in 2015?
Yes.
Were you asked to assist in the January 10th, 2015 murder at 330 McDaniel Street?
Yes, I was.
By whom?
Detective Thorpe.
And tell the jury what you were asked to do.
I was asked to pull video from the Texaco gas station in the barbershop next to the Texaco gas station. Detective Thorpe gave me the dates and times of the footage that he needed, and I recovered the footage and turned it over to him.
Now, when you were asked to assist in that investigation, did you know about any other surveillance cameras in that area besides the ones in which you pulled footage?
No.
Now, I want to go back to what you were asked to pull for the Donald Thomas murder on January 10th, 2015. Are you familiar with the systems you were asked to pull surveillance footage for?
Yes.
What businesses?
The Texaco and the barbershop.
Can you explain the system used by the Texaco?
The Texaco has a GV800 system. At the time, back in 2015, that was pretty much the system that you ran into in most convenience stores and gas stations is actually, oddly enough, it's one of the systems we kind of concentrated on when I actually went to specialized school for it. But it's a system, it's computer based. It records to the hard drive of a standing desktop, basically recording footage of the inside and the outside of the business. It's very common back then. And the barbershop also?
Yes, please.
Well, the barbershop had a night owl system, which is another one very common for smaller, in use in very smaller businesses and homes at the time. But it was one we came in contact with almost daily in our work.
Permission to approach, Your Honor?
You may.
Thank you. Detective T, I'm showing you the CD that contains case exhibit 292 Yankee Alpha through 292 Yankee Delta. Do you recognize this CD?
Yes,
What is it?
it's a video crime. It's my initials on it.
A video of what?
I think this is video. I don't remember if it's video from the Texaco or everything, but it's video on here.
Okay. Did you review the contents of the CD before coming to court?
Yes,
And does the CD contain an accurate copy of the footage obtained from the barbershop at 3:30 p.m.?
yes.
Permission to approach, Your Honor?
You may, sir.
Thank you. Detective T, who did you get this footage from?
Well, the barbershop footage I got from the owner of the barbershop, he showed me what the system was, and I pulled the video from there. The Texaco, the clerks let me into the back room where the system was, and I pulled the video.
Okay. Do you remember what he looks like?
The owner of the barbershop, black male, about 5'6", 5'7", bald-headed, brown complexion. He and I just remember specifically him. While I was pulling the video, he and I were actually talking about basketball a lot because my last name is Teague, and he's a Hawks fan.
I don't remember what he looks like.
Well, I actually seen him yesterday while we are getting ready to come into court, and he was leaving, and I recognized him from then. But I recognized him there. You recognize people, like, remember, because he and I, we actually had a long conversation while I was pulling the video.
So I want to show you, this time I want to publish what's been previously admitted as State Exhibit 292 Yankee Alpha. And to your left, can you tell me what's depicted in 292 Yankee Alpha?
The inside of the barbershop.
Correction, 292 Yankee Echo. And did you see the individual you pulled the footage from?
Yes, gentleman right here on the left.
Can you circle him?
Can you see this gentleman right here?
Can you stand and point to the big screen? That's a pointer right to your right.
Gentleman right there above where it says Cam 3.
Okay. Detective, how many cameras did you pull footage from the barbershop?
Barbershop, I think I pulled four cameras.
And how did you decide which cameras to pull from?
Detective Thorpe told me he needed the inside and outside cameras.
What is the date and time you filed on the CD?
They filed the CD were January 10th. The DVR at the barbershop was a little fast. I was like thinking about 1800, 1900 off the top of my head.
Now, when you go through a surveillance footage, do you have any way of knowing if the timestamp of the footage is correct?
Yes, you can look at the footage, at the live footage, and see what time it is, and just look at your watch and just tell what the offset is. And you advise the detective, say this is the offset on this one. Like some systems get off, or fast an hour behind an hour, or get off some, but I always advise the lead detective on the case what the offset is.
Now, did your training and experience as an electronic surveillance technician inform you of the reasons, the times that may be off on a system like the state's 292 Yankee Alpha to 292 Yankee Delta?
Yes.
What are some of the reasons?
Well, some DVR systems, depending on, say, if the system was unplugged for a long amount of time, or say power outages occurred in the area, the system go off. Most of those DVR systems have a small battery in them that it's not a rechargeable battery, it's just a battery that's placed in it during manufacturing to help try to keep the time right. But knowing batteries do die over time. So the capacity of that battery to keep up the date and time is affected. Also, with DVR systems, the regular ones that you might have in your house or something, DVRs are pretty much simple computers. The main function of DVRs is to record the video, pretty much it. And that's what most of the capacity of it is toward. So things like date and time, you have to keep up with that yourself. So a lot of people, once it's plugged up, it stays that way. So they don't know. A lot of people don't have the technological know-how to like go in and when during daylight savings time to spring forward or fall back. And sometimes it's kind of like, the best way to describe it is how if you're old enough to have a VCR, a lot of people never programmed the clock on that VCR. It's 12 o'clock forever. It just flashed 12 o'clock. Nobody ever programmed the time. But it's kind of the same principle with a lot of DVRs.
Now, was the timestamp on each of the barbershop analyzed or always the same?
Yes.
Why?
Because the timestamp is put on to the recordings by the DVR itself.
Now, was that timestamp accurate or was it off?
It was off. It was a little fast.
Approximately how much off was it?
I think it was like 40-something minutes fast.
How did you know?
I looked at my watch when I was there.
Now, did you tell the lead detective when timestamps are off on surveillance footage?
Yes, I did.
Did you inform the detective of the timestamp difference?
Yes, I did.
Now, at this time, the state moves to admit state 292 Yankee Alpha or 292 Yankee Delta for admission. And for the record, these are the 4 cameras from the barbershop list at 3:30 p.m.
Any objection to stage 292 Yankee Alpha through Delta? All right, hearing none. There.
Yes, Judge, I'm going to object to the admissibility.
Which one, or you reject all?
The entirety.
What's the basis, sir?
Foundation, and also cites to a Yancey versus State 342 Georgia 294.
Overrule, sir. I'm going to admit them over objection. And they may be published as you see fit, Mr. Adams. I'll give you continuing objection.
Thank you.
They're admitted, may be published as you see fit, sir.
Thank you. Permission to approach, sir?
You may, sir.
Detective T, I now showing you what has been marked as states 292 Yankee Foxtrot through 292 Yankee Kilo. These are steel shots from the barber shop at 330 Daniel. street, do you recognize them?
Yes, there's still shots of the video that I pulled from the barbershop.
And are they a fair and accurate representation of the footage from the barbershop?
Yes.
Permission to approach, Your Honor? At this time, the state moves to admit state's exhibits 292 Yankee Foxtrot or 292 Yankee Kilo.
We all look at, yes. Any objections to states 292 Yankee Foxtrot through 292 Yankee Kilo?
But they're from the same meeting, so we have the same foundation objection, also object to a few.
All right, I'm gonna overrule the objection. I'll note that, a continuing objection and, they're admitted and may be published as you see fit.
Thank you, Your Honor. Permission to approach, Your Honor.
Yes, sir.
Detective T, I now showing you the thumb drive containing states 295 and 296. First, for 295, do you recognize it? Well, do you recognize the content of this thumb drive?
Yes, it's the video compilation,
And
the video from the barbershop and the gas station.
have you reviewed the contents of the thumb drive prior to today?
Yes.
And what are the contents?
Video from the video that I pulled and the compilation of the videos.
From the
Gas station and the barbershop.
with respect to the gas station footage, is it a fair and accurate representation of the footage you're saying from the gas station, Texaco gas station, and then on the north side?
Yes.
For 296Y, which are snippets, the compilation you referenced, have you viewed those snippets before coming to court today?
Yes.
And are those a fair and accurate representation of the footage you're obtaining from the barbershop and Texaco?
Yes.
Permission to approach, Your Honor? Detective T, who did you get the Texaco footage from?
The clerks at the store.
How many cameras did you pull footage from?
I think the Texaco, I think I pulled 16 cameras.
How did you decide which cameras to pull from?
Detective Thorpe advised me he needed the inside and outside cameras.
And was the timestamp on each of the Texaco cameras files the same?
Yes.
And this time the state moves to admit State's Exhibit 295 Yankee and 296 Yankee.
Any objection to states 295 Yankee or 296 Yankee?
I'm sorry, Judge.
I said, do you have any objection to states 295 Yankee or 296 Yankee?
Yes, same objection, just based on foundation. And specifically, the last one, I'm sorry, the exhibit number again for that last one?
296 Yankee.
That's the compilation, is that correct?
No, that's the snippets of the barbershop in the Texaco.
Yeah, could have an objection to 296, I think because of the way it's compiled, I would consider the, well, cumulative as well as confused with the jury, so that makes.
I'm overrule the objection and make them over objection. I'll give you a continuing objection. You may publish as you see fit, sir.
Thank you, Your Honor. Detective T, did you view the systems in real time?
Yes,
And did the systems accurately show outside and inside of the text?
yes.
Permission to approach, Your Honor?
You may.
Detective T, I'm now showing you steel shots from the Texaco gas station at Northside and Meghann. States 292 Yankee Lima through 292 Yankee. No, do you recognize?
Yes.
And how do you recognize it?
It's footage from the outside of the gas station on north side of McDaniel Street, looking at actually the intersection of McDaniel and North Side.
We have very accurate representation of the footage you grew from the Texaco gas station.
Yes.
Around this time, the state was admitted, state 292 Yankee Lima.
Lima.
Pardon?
Lima.
Lima.
Not Lima. Lima. Lima's the pen. Military people around the world are just cringing at this point in time.
Mhm.
Yes. 292 Yankee
Lima through
Lima.
November.
Yes.
Mhm.
I don't believe those are the ones we saw.
Okay.
You want, all right, you take a look at them first.
So in response to the court, same foundation objection.
All right, sir. They're admitted over objection. I'll give you continuing objection. They're admitted and maybe published as you see fit.
Thank you, Your Honor. Detective T, did you also view the barbershop system in real time?
Yes.
And did the cameras accurately capture outside and inside the barbershop?
Yes.
And at this time, we will publish states 292 Yankee Alpha up to eight minutes and 32 seconds. 8:32:50. That's about 30 minutes.
Okay. Ladies and gentlemen, you good? You want to take a comfort break before we see this video? I think, we good? Okay, all right. Anybody else out here? All right, roll it. We're gonna take one afterwards, okay? So, all right, okay. All right.
Yankee Alpha on the screen?
Yes.
And what is the time and date of 292 Yankee Alpha?
It shows 110 of 2015, 8 p.m., which we've already been over as fast.
And what camera angle? Or what camera?
We're looking at, see camera number 1.
Is that, what side of the barbershop is that?
That would be the side of the barbershop facing McDaniel Street, looking northbound.
Is that the east side of the barbershop?
Yes.
Detective T, do you know any of the individuals in this photo?
No.
And for the record, they're kind of just standing around.
Yes.
Detective T, is this prior to a shooting occurred at this location?
Yes.
And for the record, at 8:01:47, are people kind of just like congregating around the SUV, Detective T?
Yes.
At 8:02:31, has any shots been fired yet?
No.
Okay, pause right there. At 8:03.
Yeah,
Do you know that individual?
no,
Do you see a gentleman in a camouflage jacket and a skull cap, go inside the vehicle while they're congregating?
yes,
Do you know that individual?
no,
Do you see the camouflage jacket and the skull cap?
yes,
You know that individual?
no,
Did you know them as kind of person?
no,
You think T are still congregating?
yes,
At 820 are still congregating? 808, I'm sorry.
807, yes,
For the record, at 840, 808, 40, then the 808, 40, I'm sorry. 808, 41, then the shooting just take place.
Yeah, but it, on my monitor, didn't show the shooting.
Did you ever monitor the call?
Yeah, it jumped to 808:44. So,
Yeah, the one, please. Eight oh eight.
yes.
For the record, we're continuing from 808 to 44. 58, do you see police arrive?
I see lights right quick. I see a blur of lights. So
We'll continue.
okay, now I see the blue lights.
For the record, 8:13:28 is when you see blue lights.
Yep.
Detective T, the surveillance video taking capture any sound?
Some do, some don't.
Did this one?
No.
record, Detective T, we are following at 8/24/19. Detective T, is someone being wheeled on the parking lot on Gurney at this time?
Yes.
Eight, 24/21. Your Honor, the court video froze. I'm going to just rewind it, just add it. again, for the record, we're paused at 8:40. Detective T is the second person being wheeled from the scene on the journey.
Yes.
Do you know the person being wheeled?
No.
Detective T, we're gonna pause at 8:32:50. And finally, for the record, do you see a third person being wheeled from the parking lot over there?
Yes.
Do you know this person?
No.
Detective T is here. Detective T is here in additional amount of footage left on this camera angle that you will. Sure. Detective T, is there an additional amount of footage left on this camera angle that you pulled that has not been shown yet?
Yes.
Detective T, is there any more shooting shown on this angle footage beyond what we have already seen?
No.
Your Honor, at this time, the state is getting ready to publish 30 minutes of the next angle footage if the court deems it appropriate time for pausing at this time.
Yes, that would be appropriate. Members of the jury, how about we take about 15 minutes, okay? All right, we're in recess for 15 minutes. All rise. Members of the jury and counsels, I'm gonna go ahead. I need to make a phone call to get our Zoom the working again, so just bear with me. So you might as well sit in your headquarters and be at ease. Okay, so once we get that resolved, we'll go ahead and continue. Okay, all right. All right. Now she's got to call tech support. Of course. Let me check. How much time? All right, ladies and gentlemen, our jury is left. So you can have a seat, please. We're just going to recess in place. See if it you all. We missing, what's her name? I'm sorry, let's see.
Mr. Adams, we're getting it, Mr. Matthews.
Okay. All right, do we have everybody now? Let's see. Okay, all right. Councilors, just to fill you in on our impromptu bench conference, which is the subject of what we like to talk about at this point in time. It appears that our internet is still out or down countywide, or at least on this side of the building. So, given the fact that we have been down more than an hour and it looks like the internet services are still not working, it might be best to just recess for today. Councils, with your concurrence, or even with it not your concurrence, I'm going to go ahead and excuse our witness here and have him come back. Detective D, is Friday afternoon, 1 o'clock okay with you? Work for you? Okay, all right. Council, we'll go ahead and recall Detective T here for 1 o'clock on Friday, okay? And see if we can complete his testimony at that point in time. All right, any issues?
What's happening tomorrow?
The state's gonna call some additional witnesses, but we can talk about that in just a minute. Okay? All right, let me go ahead and call our jurors out and excuse them when we can excuse our witness for the day, and then we can talk about any ancillary issues, all right? All right, summon our jurors, please. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Newman. All right, ladies and gentlemen, given the fact that our internet is still not working and we don't know when it's going to come back up, and given the fact that we were displaying a medium that needs to be, we need internet in order for us to do so, it would be the prudent thing to just recess you for today, okay? Detective T, we'll see you tomorrow, I should say Friday at 1, if you could come for 12:30 and we'll start about 1 o'clock, okay? All right. And remember, sir, do not discuss your testimony with anybody except the attorneys in this case. We'll see you then. Okay, ladies and gentlemen, any ministerial inquiry with me before we recess you for today? These kind of things happen, so not anybody's fault. All right, I could blame somebody, but it wouldn't really do anything, huh? Why do you want to blame Ingram? What do you do? What do you do to you? What do you do? It's what do you do to you? I mean, come on. All right, ladies and gentlemen, I will go ahead and give you your admonitions at this point in time. Remember, as you leave and depart this space to go to wherever you live within our great county, do not discuss anything that you may have heard at any point in time with each other as you leave and go in ones and twos or in a larger group, or as you sit back there in your headquarters at your deliberation room. Remember, it would be a violation for you to also recap or handicap the testimony by going and saying, hey, what did you think about such and such? Or review each person's testimony at this point in time. Remember, you cannot do that until such time as the court directs and instructs you on that particular process. Remember, you can also do not go to any third-party sites, to do any additional research, any reference materials, phone a friend, or anybody else to aid or otherwise augment your understanding. The only thing you can consider and that's been presented lawfully within the four walls of this courtroom. That also pertains to any addresses or sites that you may have learned thus far in this particular trial. Remember, do not go by and visit any of those scenes. Do not take any pictures of those scenes. Do any artist renderings of those scenes, or otherwise discuss anything that you have learned either with each other or with anybody else. It would be a violation for you to engage in that. Ladies and gentlemen, also please resist temptation to listen to any recaps or reaccountings of this particular trial as it may be portrayed in the media. As remember, you can only consider what is presented in this courtroom that's been lawfully for your consideration. You cannot consider any outside or extra sources. All right, and ladies and gentlemen, as you leave today as well, please put your notepads in the basket. Do not take those with you outside that space. You'll get them back when you come back tomorrow, okay? Tomorrow we will start up 9:30 for an anticipated 10 o'clock start time, and we'll see where the day leads us at that point in time. Hopefully our internet will be working, or we will do alternative presentations of witnesses, but we'll see what tomorrow brings, okay? All right, any other further inquiry of me? All right, ladies and gentlemen, thank you for your extreme patience that you've given and the patience you'll continue to give us. It goes without saying on behalf of all our participants, okay? All right, unless you have anything of me, ladies and gentlemen, we're going to recess you till tomorrow at 9:30. We'll see you for 10 o'clock start time. All rise. Don't even think about it. I thought he was going to.
Please be seated. Our jury has left us.
All right. What inquiry do you have of me? State, are you prepared to call on some witnesses or that may or may not require internet access?
We'll just have to old school it, so we will
That may be true.
make it happen.
Okay. All right. Who are you planning on calling tomorrow? We're going to, counsels, we appreciate your indulgence with our current witness, Detective Teague. His better half is having a procedure tomorrow, and that's why he cannot join us. So I appreciate you all giving him some grace and consideration. So we'll we'll go ahead and see him on Friday afternoon. All right. Okay, anything else before tomorrow?
We have Mr. Wise, Mr. Davis, Mr. Hendrick, Dr. Henniger, and Mr. Thomas Senior on deck for tomorrow.
All right. Okay. Councils, unless y'all have anything of me, or any other inquiry, we'll see y'all tomorrow morning for 9:30 for anticipated 10 o'clock start time. All right? All right.
That gentleman, Mr. Thomas Senior, is the one that, state filed a motion under 24-8-807, and I filed a response for, trying to get in residual hearsay.
Okay.
He would be one of the last witnesses if we even reach him tomorrow. So prior to us putting.
Do you want to take up the issue right now? I mean, I'm prepared at this point. I read the state's request and Mr. Steele's response, which I'll include as the next court's exhibit in order.
John, if we could take it up tomorrow.
I'd rather not take it up
well,
more.
I'll give you
Reason being is because I can take it up now and then we don't have to stop tomorrow because we've got a few minutes. It won't take that long because I've kind of got just some kind of inquiry about it anyways. Okay.
Okay.
All right.
Just 1 second.
Okay. I'll give you a few minutes to get your materials in order.
Didn't even, thank you. Sorry. Nope.
All right. Request by the state. The court has basically 3 areas of inquiry, and I'll let you all, respond to them 5 minutes each. Of course, the concern is the traditional guarantees of trustworthiness. Well, first there's notice, and assuming that there's notice in this particular case, there arguably there's some notice in this particular case of what was sought to be introduced. However, the court's kind of concerned. The court has the first concern about exactly what was said, what statements were said, line and verse. Second thing is traditional guarantees of trustworthiness. The court's concern is this is purportedly the decedent's father who the court would have some concerns about inherent bias to why his son, about his son and the person that took his son's life. Then next would be the confrontation clause. And since arguably the defendant or defendants wouldn't have had an opportunity to cross-examine the decedent, the confrontation clause does apply in this particular circumstances when you're trying to get in residual hearsay under 807. And then the fourth issue that the court wants to discuss is it's cumulative of things that we've already been testified to. The fact that there was beef between Donovan Thomas and or some parties in this case has already been testified to by at least 3 or 4 people already. So those are the 4 things I need you to address for me. So, and there's something I missed. Of course, I'll be more than willing to listen to it, but try that framework. So, Ms. Hilton?
Yes, Your Honor. Thank you, Your Honor. So first, I'll address the notice issue, Your Honor. We served notice for this particular testimony on May 23rd, 2024. Your Honor, we served notice based upon the line of inquiry that we are hearing regarding some of our witnesses regarding the relationship between Mr. Williams and Mr. Donovan Thomas Jr. at the time of his death. There have been a series of cross-examination questions, and I'll go specifically when Ms. Shawana Edmond was on the stand last week, I believe last Monday. There was a line of questioning from Mr. Steele regarding the fact that at the time of Donovan Thomas Jr.'s death, that Mr. Williams and Mr. Thomas Jr. were friends. And that has been a point made by Defendant Williams through his counsel on multiple occasions through multiple witnesses. And so what the state realized, especially after the inquiry with Ms. Edmond, that it was important for Mr. Donovan Thomas Sr., who had a different relationship with his son than what the mother had, to talk about the fact that at the time of Mr. Williams' death, they were not that friendly. What Mr. Thomas Sr. will testify to is that in the summer of 2014, all the way up probably through about September of 2014, there was a cordial, a good relationship between Mr. Williams, Jeffery Williams, as well as Brian Birdman Williams. That over the course of the summer, there are some pictures that you have seen in which Mr. Donovan Thomas Jr. had went to both Miami and LA with Mr. Brian Williams. And it was a good relationship. However, in the fall of 2014, that relationship changed. And the reason or the catalyst for that change is that Mr. Donovan Thomas Jr. thought that Brian Birdman Williams was taking artists away from a record label called TIG, which is called Think It's a Game Records. Think It's a Game Records at the time was the record label that Rich Homie Quan belonged to, or the Quantas Lamar. And what Donovan Thomas Jr. began to see or observe, or what he thought, was that Birdman was trying to take Rich Homie Quan from Think It's a Game Records and bring them over to Cash Money Records. And so at that point in time, Mr. Donovan Thomas Jr. would have conversations with Rich Homie Quan about not going over to Cash Money, but staying with TIG Records. In the course of that, Mr. Donovan Thomas Jr. would have conversation with his father about the concerns that he had of Rich Homie Quan possibly going over to Cash Money and not staying with TIG. Why that is important, Your Honor, is because at the time, we believe that Jeffery Williams was either signed to Cash Money or had a management deal with Cash Money, but he had more of a relationship with Brian Birdman Williams and the Cash Money side of the house. And so there was some conflict with Rich Homie Quan. And so we believe that in the latter part of 2014, what Mr. Donovan Thomas Sr. would testify to is that his son decided to not have as much of a relationship with both Jeffery Williams or Brian Birdman Williams. And so he began to distance himself from the two of them. There was a specific encounter that he remembers very vividly, which was a video shoot. I believe it was Mr. Jeffery Williams' video shoot. And when Mr. Donovan Thomas Sr. and Mr. Donovan Thomas Jr. went to the video shoot, they saw Mr. Jeffery Williams there, they saw Brian Williams there, and they saw another TIG artist there. However, the owner of TIG was unaware of this video shoot and was not present. At that moment, both of the Thomases left, and at that point, that's when really the tension or the frustration developed, and he did not want to deal with anything that was not TIG Records. And so we're talking about October 2014, November 2014, later in the year, that there was this distancing between the two, which is opposite of what we believe that the defense is trying to purport, that there was this great friendship in January 2015, because that was not the case. And so specifically, there are two conversations that Mr. Donovan Thomas Sr. remembers his son having with him. These were two face-to-face conversations, again, he believed it was fall of 2014, and specifically his son came to him very concerned, thinking that Rich Homie Quan was going to leave TIG Records, that he expressed to his father that he was trying to show Rich Homie Quan everything, showing him the studio that they had built for him, and really trying to convince him to stay with TIG and not go over to Cash Money Records. And the reason why that is relevant, Your Honor, is we believe one of the theories of why this murder occurred is there was a desire to have Rich Homie Quan on Cash Money Records, and two people were preventing that from happening. Corey Lamar, who is the father of the Quantas Lamar, as well as Mr. Donovan Thomas Jr. And those two individuals were preventing that from occurring. And so these conversations that he was having is not specifically towards Jeffery Williams, but specifically towards his concern with Brian Birdman trying to steal Rich Homie Quan from TIG and bring him over to Cash Money Records. As far as this having some guarantee of trustworthiness, that's why we believe that you need to hear from Mr. Thomas yourself. Generally in these hearings, Your Honor, as you are aware, the court can assess credibility from the witness itself.
Okay, let's assume that I do that. How are you going to get over the confrontation clause?
Your Honor, this is not testimonial because confrontation.
I disagree with you.
Well, Your Honor,
it is testimonial.
It's not testimonial because testimonial evidence is evidence that's made directly to the police.
No,
this is not.
Not necessarily. Not necessarily.
I'll bring some case law, Your Honor, but testimonial evidence is evidence that is made in preparation for trial, generally to law enforcement. This
Okay,
is
but
not,
even if it's not testimonial, you still got a confrontation clause issue. How are the defendants gonna?
but this is why this is residual hearsay, Your
No,
Honor,
but
because
residual
what this,
hearsay, if you're gonna introduce it against the defendant, it's still gotta pass the confrontation clause.
no, Your Honor, when you're talking about confrontation.
I disagree with you about that. It's gotta pass the confrontation clause. In fact, there are, you all like to slight Carlson a fair bit, so let me go back to what Mr. Carlson says about the constitutional considerations. While much of the evidence offered under 807 will pass Sixth Amendment muster, cases state that if a hearsay statement is testimonial, confrontation clause prevents its admission at trial, even if it falls within the hearsay exception, unless the declarant statement is unavailable and the defendants had a prior opportunity to cross-examine the declarant. So the issue you're still going to have is, well, is just general confrontation of this particular witness. And then also, I'm concerned about just the nexus in terms of what you're trying to get into at this point.
When you, I guess two things.
The nexus being that of what exactly Mr. Thomas is going to testify to. I mean, you laid out for me kind of a relationship driven or I don't see the nexus. I'm having a hard time seeing that.
Which nexus, Your Honor, so I can be clear,
The nexus in terms of what does Mr. Thomas's statements about his son, because finally you boiled it down to there's two conversations in the fall of 2014 that you want to get into. Have you reduced those to writing?
Okay, Your Honor, it's in the summary on page 44 and 45 of Mike Sprinkle's supplemental report that was turned over in discovery. In discovery 1 back in July of 2022.
Well, you need to all print that because I don't have it. So you need to print it for me. But
I will print it, but the nexus, and I want to make sure
because the next, I mean, because it's you're telling me that Senior had conversations with Junior. Junior was concerned that basically there was some pilfering that may have gone on in terms of artists. But what does that have to do with Mr. Williams and any of the other defendants?
Sure, specifically Mr. Williams. Mr. Williams and Rich Homie Quan were a part of that group called Rich Gang. You've heard about testimony about Rich Gang in here.
Yes, I have.
And so at that point, Rich Homie Quan was a part of TIG Records. He was not a part of Cash Money. So they were trying, but Mr. Williams was a part of Cash Money. So we have TIG, Rich Homie Quan. You have Mr. Williams either loosely associated or having some more affiliation with Cash Money than Rich Homie Quan. Birdman, who owns Cash Money, is trying to pull Rich Homie Quan over to Cash Money. That is an issue because Mr. Donovan Thomas is trying to keep Rich Homie Quan over to TIG. So there's some conflict, there's some tension there. At the end of the day, if Rich Homie Quan doesn't come over to Cash Money, they can't do everything that they need to do as far as albums, as far as the music, as far as any of those things. And so that can essentially affect, at least we can present that to the jury, what Mr. Williams can do at that time as far as his career, as far as what's going to happen with his career. And there's some tension, there's some conflict because Donovan is trying to keep him on one side and they are trying to pull him over to another side. And there's conflict and there's tension. And what Mr. Donovan Thomas expressed to his father is that he began distancing himself, not just from Birdman, but from Jeffery Williams. The defense has continued to purport that at the time of January 2015, Mr. Donovan Thomas and Mr. Williams were great friends. That is not true.
Okay, but you've
so that's the nexus. So we have to be able to show that there's some conflict there, that we do not believe that in January 2015, they were as close as the defense is trying to court them.
The defendant's assertion.
That's a defense. Our assertion is that
That's the
they're not.
defendant's assertion, but you've also brought out the fact from numerous witnesses already that there was tension and beef between these particular parties.
Not between Donovan Thomas, though. People have talked about, but the person who can speak the best about it is Donovan Thomas Sr. because he had direct conversations with his son about his son's feelings towards these parties at the time of ending in 2014 and early 2015.
All right.
And what we talked about in testimony is conflict between Lil Wayne and Mr. Williams, not specifically Donovan Thomas. What has been purported, at least the evidence that has come out, is that Donovan Thomas, the assertion that they were friendly at the time in January of 2015. And this is in direct contradiction to that.
And if it's not testimonial, what about the 403 consideration? It's certainly, because I do have to balance that if I do find it. So why would you think that this is not highly prejudicial, more than probative? Because, you also got, I have to consider that too.
Because, Your Honor, the state has to prove motive, and we have to prove a reason why this occurred. What defense has purported in opening, what defense has purported throughout the entire trial, there's no reason why Mr. Williams will want to have him killed. There's no reason why YSL will want to have this individual killed, and the state has to be able to prove motive. We do not have to prove motive. However, there is a reason behind, or the state believes that there is a reason behind this senseless killing. And so the state can purport and give that information to the jury. They can choose to believe it, not believe it, but we have a theory of why this occurred. And there's nothing prejudicial about Mr. Donovan Thomas Sr. speaking about his son's feelings at the time of this murder. And the conversations that he had, he doesn't say, my son said, if I die tomorrow, it was Mr. Williams. That might be prejudicial, but it is Mr. Thomas's conversation about his concern that Rich Homie Quan was going to go to another music label. There's nothing prejudicial about that statement to Mr. Williams, except for the fact that Mr. Donovan Thomas is telling his father, someone he has a close relationship with, someone who he talked to almost every day. This is the testimony that Donovan Thomas Sr. will give, is that my son came to me with a concern that someone he's mentoring, someone he has developed a relationship with, may leave this record label and go to another record label. There's nothing prejudicial to any of the defendants with that particular statement. So we do believe that there's nothing prejudicial about that statement in this. And I'll pause, but I'll look up the testimonial. But again, Your Honor, I believe the testimonial will solely be if this was a statement made for the purposes of trial. And it's not.
I still have to go. I'm going to go trustworthiness.
Yes, Your Honor.
Still have to go through there. Even if I don't find it to be testimony, it still has to be balanced under 403.
Yes, Your Honor. And I take this in comparison. Many of the residual hearsay cases, Your Honor, are domestic violence cases.
Oh, that's what comes up.
That's what comes up. And
but ordinarily, those are a lot more tighter in the sense that you have interplay between, unfortunately, the decedent and the victim. And you also have third parties that are very much usually around, or unfortunately see those particular, or that particular victim talks to on a regular basis.
But that is what's happening here, Your Honor. Mr. Donovan Thomas Sr. will say he talked to his son every day. He has a different vantage point. If you recall Ms. Edmonds' testimony, Ms. Edmonds knew her son, but Donovan Thomas Sr. went to video shoots with his son, went to events with his son in the music industry. So he had a very close relationship with his child, such that these conversations were very natural for them. In comparison to Ms. Edmonds, Ms. Edmonds said, I knew certain things, but she didn't have as much detail. He spoke to his father more about what was happening on this music entertainment side. The father had been to video shoots. The father had, may or may not have been, I have to confirm, may have been in Miami when they did the lifestyle video. Mr. Donovan Thomas Sr. spoke to his son, was very involved in the fact that Mr. Donovan Thomas Jr. had created his own independent music label. Another one of his sons, Marquavius Curtis, was a part of that. So Mr. Donovan Thomas Sr. has a very more knowledge about this side of what Mr. Thomas was doing versus say Miss.
Do you have the statements? Did you find those? Discover, can I see those?
Yes, Your Honor, permission to approach?
Yes. I'm just gonna read them in the record so that we have them for consideration.
Okay, yes, Your Honor, it starts at the end of page 44 and turns over to page 45.
All right, if you hand those to Mr. Kearns. This is a.
The last thing is on page 44, Judge.
Okay, what am I looking at to begin with? This is Mr. Sprinkle's, what is it?
So Mr. Sprinkle, back in 2016, met with met with Donovan Thomas Sr. About.
So this is a report from Mr. Sprinkle.
Correct. But
Okay, and where does it go from? Am I supposed to consider on August the 2nd, 2016?
Yeah, when you said you wanted to read, yes.
Yes.
So August 2nd, 2016.
Through what?
And then it goes all the way up to page 45. The last word is them.
Oh, okay. Have you all broken out what exactly Mr. Thomas is going to, Senior is going to stay say? Because these particular statements that are contained within the August 2nd, 2016 recount of Mr. Sprinkle elicited a lot of hearsay. So do you have it broken down into what exactly he's going to say? Because I'm sure he's probably not going to say, stuff like there were disputes going on in the streets,
Correct. The only,
or talk about stuff like that, because that certainly would be hearsay. Do you have something in particular that you've kind of distilled out that he's going to testify to?
specifically, Your Honor, so he's going to talk about a number of things, not statements, but his understanding of different relationships, because I think that's the foundation to get to these statements. The specific statements that we listed that would be hearsay would be the conversation he had with his son. I believe it was.
Okay, hold on. But let's back up for a second. You have him talk about relationships. What relationships you gonna have him talk about?
Sure, and I can pull it up, Your Honor.
And then my next question is, does he have personal relationships or do you have a basis or foundation to talk about those?
Yes, he does. So he's going to talk about his
son. You're going to talk about his son.
And his other children, because that is important. So Mr. Donovan Thomas has 5 children.
What about his other children that's important and relevant for this analysis?
So let me start with Donovan and Dontavius and Marquavius Curtis. Marquavius Curtis is also known as Greedy. He is a member of If Gang. Greedy shares a mother with Kelvin Watts, which is also known as Shell Kel. These are individuals that the state's theories that YSL has issues with. They are part of If Gang, Bird Gang. He also has a daughter by the name of Sequoia Cade.
What's your name?
Sequoia.
How do you spell that?
S-E-
That's from Miss Weaver.
Sequoia. The last name Cade.
Cave?
Cade.
Yes, ma'am.
She has a child with Calvin Treadwell, also known as OG Bentley. You've heard testimony about him as he was a part of the incident with Dexter Montgomery, the shooting in 2015, on April 12th of 2015.
Okay, so he
He's
can
gonna-
testify about this relationships with his children.
Correct.
Okay.
Then
all right.
he's going to
Why
talk.
wouldn't that be cumulative already? Because we've heard that, remember?
You haven't heard it with clarity. If we're talking about Miss Edmonds.
Clarity. I just remembered it. So why wouldn't it be cumulative? I'm just asking because I'm sure
Sure.
Mr. Steele's going to ask you that same question in just a second. He's going to say it's cumulative of things that we've already testified to. So what's distinguishing about this?
Because when I heard what I believe some of the testimony that came out last week with Miss Edmond, that was not clear. I believe that there was a thought that Kelvin and Donovan were actually brothers. They are not. They share a brother.
But you all, through your examination, distinguished and pulled that out and clarified it. So
it was not, Your Honor. It was not distinguished that they are not actually blood related.
Well, you all being the state asked a lot of clarification questions because it was kind of confusing to begin with, and you all kind of bared that out. So I mean, that's from my memory of just listening to the testimony. So what's still kind of I would say unclear at this point.
So in addition to that, I think the state and the court sees that clarity of their relationship differently, but if the court believes that it was clear, we can move on. The next portion of that is Donovan Thomas, his aspect of the music industry, what he was doing in the music industry, the fact that he had his own entertainment label, that testimony has not come out.
Okay, that hasn't come out yet. I would agree with that. In terms of so his dad's going to testify about I guess, the development of his business and what he was doing.
Correct. That
Okay.
under his label was his brother initially, which was Greedy.
Okay.
Also about certain individuals, Gervin Fly Henry.
Who, I'm sorry?
Gervin Fly Henry.
Gervin?
Gervin, Girvin.
Okay.
Henry, who is the owner of TIG Records. The father has knowledge of the beginning of that relationship, how that relationship started, when that relationship started, what Mr. Donovan's role was as far as securing artists for that label. Specifically, he brought Rayshawn Bennett to TIG Records. That's the person also known as Lucci. So
Okay.
that testimony has not come out yet.
No. Okay. All right.
In addition to that, Your Honor, he can talk more specifically about his son's relationship with DeQuantes Lamar.
DeQuantes?
DeQuantes Lamar, DeQuantes, also known as Rich Homie Quan. Again, he could speak to Mr. Donovan Thomas Jr.'s relationship with Rayshawn Lucci Bennett. That's going to be relevant because testimony will be forthcoming that Rayshawn Lucci Bennett's mother's home was shot up after Donovan Thomas was murdered. Mr. Donovan Thomas can also speak about, again, the relationship between Donovan Thomas Jr. and Mr. Jeffery Williams from his observations. He'll also be able to speak about the relationship between Brian Birdman Williams and Donovan Thomas Jr. Again, what I just talked to the court about as far as the summer of 2014, what was happening.
Well, go back to Brian Birdman Williams and Donovan Thomas Jr. Is that what you said?
Yes, Your Honor.
Okay. All right.
In addition to that, what I spoke about earlier, Your Honor, Mr. Donovan Thomas Jr. can talk about what was happening in the summer of 2014. He will testify that the relationship between Mr. Donovan Thomas Jr. and Mr. Jeffery Williams, as well as Mr. Donovan Thomas Jr. and Mr. Brian Birdman Williams, was cordial, was good, that, you know, Mr. Donovan went to video shoots and things were good. He will testify to that. But he will also testify that in the fall of 2014, that began to change specifically for Mr. Donovan Thomas Jr.
Okay.
And then that is, again, the conversation that I am speaking of, the hearsay conversation. It's sometime around, again, October or November is the conversation that I talked about where Donovan Thomas Jr. expressed to his father some concern about Rich Homie Quan leaving. And then the second conversation, Your Honor.
Yeah, but and you said that, the two conversations, but what I would like to see is, or something, or hear, is what exactly those conversations were. I think there's some predicate stuff that maybe that's from the court's perspective, maybe relevant to here, to put certain things in context. But in order for me to make some further determinations, you would probably need to reduce exactly what you're trying to get Mr. Thomas Sr. to say, because that would be important.
Okay. Is it possible he is prepared? We were prepared to bring him in to testify because for the court, my experiences in residual hearsay motions, that witness will come and testify. So you can hear directly from his mouth what the conversation is. So I don't write something down.
Okay, well.
So he's prepared to come tomorrow morning. We can make him available.
Okay, all right. Thank you. I've given you more than 5 minutes, probably about 30. Mr. Steele? That's okay. Take your time, sir. Ms. Hilton and Ms. Love, can you all send Miss Weaver, the pages from the case supplemental report, pages 44 and 45, for purposes of the motion? No, okay, yes, that's fine, when you get it. Oh, it's up now, okay. You know, it's up now, we have it now. Okay, so I'm gonna give you all this back, so you can have it. But if you all could send the court, yes, please make it the next court's exhibit, Christina, thank you. All right, sir, I'm listening.
Good afternoon, Your Honor. Good afternoon, everyone. Your Honor, I ask you to not permit any statements under OCGA section 24-8-807 for the following 4 reasons. First of all, the notice itself is late. I don't have any, I'm going to hear for the first time when you hear for the first time, I guess tomorrow, what the exact statements are. That violates the law. And that is cited, and I put all this in my motion or response from Mr. Williams.
Do you have a copy of that, sir?
I could email it to you if I don't have a hard copy.
Let me see if you emailed it to all of us?
Yes, on Friday, this past Friday.
All right, so I have your response, or what do you invite me to look at?
Well, the first paragraph, in paragraph 2 actually, cites Carter and Brooks, and OCGA section 24-8-807, Georgia courts have adopted the 11th Circuit, and they call it the last resort. That's a quote unquote attempt by a party to introduce hearsay evidence and should be used, and this is a quote from the cases, very rarely, and only in exceptional circumstances, and only when there exists certain exceptional guarantees of trustworthiness and high degrees of probativeness and necessity. So I don't believe that in this case, the state can meet that requirement. In addition to that, in paragraph 3, Your Honor, under Snyderman, SNEIDERMAN versus state, that's 336 Georgia Appeal 153. That's in footnote 7, 784 Southeast 2D 18. It's all in my motion, my response, 2016. It was overruled on other grounds. But specifically, the state should have given this notice before trial. They did not. And they're supposed to give exactly what you're asking for now. What are the statements? They did not do that. They never said before their Thursday filing of last week that they're seeking to admit this, these statements under 24-8-807. So that has been violated. The next one is the statute itself. It's in paragraph 4. OCGA section 24-8-807 requires, among other portions of the test, that the hearsay statement is more probative on the point for which is offered than any other evidence which the proponent can procure through other reasonable efforts. The proponent in this case is the state of Georgia. And Your Honor, the way I understood what you were just told, we're talking about that Rich Homie Quan was trying to be led away from TGI Studios record label to go over to Cash Money Record. TGI Studios is owned by a gentleman, as the Honorable Ms. Hilton said, named Girvin, G-I-R-V-E-N, may be wrong, Henry, like the King Henry. He's on the state's witness list. He's available. They gave me a phone number for him. Rich Homie Quan is named Mr. Lamar. DeQuantis Lamar is spelled earlier. He's on the state's witness list for this series of witnesses. Mr. Brian Birdman Williams is on the state's witness list. So it is hard to swallow that the state passes the statute itself in 807 that states that the state can get this information, cannot get this information from someone else with reasonable efforts. What they're saying is that Rich Homie Quan is being courted by two different record labels. Well, they have the record label people right here and Rich Homie Quan, or excuse me, Mr. Lamar, his performer known as Rich Homie Quan. So I ask you for all of that, for all those reasons so far, to deny their motion. In addition, they wanted to explain about a relationship between, through hearsay, between Donovan Thomas Jr., God forbid, deceased, and Rashawn Bennett. Rashawn Bennett is on the state's witness list. He already pled guilty in another case in this courthouse, and there's no reason that he can't be a witness in this case. So again, the state has other reasonable alternatives through reasonable efforts. And then, Your Honor, it's paragraph 5 is what they put forth, they being the state of Georgia, in the Thursday late notice. And they say what the supposed statements are, and they really don't give very good statements. So I guess tomorrow is going to be the real notice. So I'm objecting to the late notice. Then in paragraph 6 of our response, Your Honor, Mr. Williams' response, this is a new case. It was decided May 15, 2024, but it's not new law, but it just happened to be here. And it's Hall, H-A-L-L versus state, and I cited it. It's too new, so the case number is A is in Elisa Alpha Appeal. 24A is in Elisa Alpha Appeal 0568. And it was May 15, 2024. And what they're talking about, the courts are saying that under 24-8-807, it's supposed to be so rarely used, and there has to be such circumstances which give guarantees of trustworthiness that it's the equivalent, Your Honor. You're gonna have to find this is equivalent to either a cross-examined former testimony or statements under belief of impending death, or statements against interest, or statements of personal or family history. None of that is here. So for all those reasons, I ask you to, right now, without even hearing from Mr. Thomas tomorrow morning, that the state just utterly failed the test. You know, if the law gives us our rules, whether we like them or not, the law gives us our rules, and the state here did not give proper notice. I heard your concerns at the beginning, Your Honor. You said the first one was notice. The second one is guarantees of trustworthiness and inherent bias. I've answered those two, I believe. The next one is what is said exactly. That's part of the notice. I don't know. The next one is there's no cross-examination of deceased, which triggers confrontation clause. And you're right. And Ms. Hilton's right. I agree with Ms. Hilton that testimonial evidence is evidence that is going to be used for a prosecution, just like you did in the Pitts case. But
in this case, the statements are found in Mr. Sprinkle's report, which is a prosecutor's report made for the purposes of prosecution.
And also, we can't cross-examine the deceased. So I'm stuck with what the father who, you know, and I feel terrible for the man. I mean, everyone feels nothing but sympathy for that family. I mean, we saw the video. I mean, it's outrageous. But how do we get a fair trial by cross-examining the father on statements made by the deceased, supposedly made, when the real witnesses are here anyway? So I can't get over the confrontation clause issue. We should have the right to cross-examine Mr. Gervin, Mr. Bennett, Mr. Lamar, Mr. Birdman, Brian Birdman Williams. And then you asked about cumulative, because the beef was already testified to, and the state responded that not really. And I challenge that because I sit here attentive every day, and I go back and I review notes every single day. Detective Gaither said that this beef, that's what it's been called, goes back to October of 2014. Detective Dennis said this beef goes back to 2014. Over strenuous objections, the Honorable Court allowed based upon your investigation, witness after witness say, we had a shooting here, we had a drive-by here, this is the victim and this is the person. In this case, people from YSL were the victim. Mr. Shannon Stillwell was a victim. The person next to him got killed. In this case, the victim was our people, and the defendants are people who are associated with YSL. So, Your Honor, I will answer any of your questions, but I am objecting under the law. And if the state really wanted this to come in, they should have, just done what you tell us to do, what everyone tells us to do, just follow the rules. And they've all been broken, and we're getting noticed during trial. And I don't think that that's something that courts overlook. I mean, we'll obviously go with whatever you say, but to me, there are real witnesses here who could testify. If Donovan Thomas was concerned that Rich Homie Quan is getting courted by Birdman Williams, Rich Homie Quan is a better witness than Donovan Thomas's father. If Rich Homie Quan is concerned that Jeffery Williams is trying to get him over to Cash Money Records, Rich Homie Quan is a better witness than the father of Donovan Thomas Jr. Those are my...
my questions being is, I think he can, they're trying to get Senior, the father of Donovan, to testify about the relationship between his children and that. I have some, I believe that's been testified to, but I think he could probably give some background and fill in some, the full extent of that particular relationship between children and those folks. I guess my second thing is with Donovan Thomas and Mr. Garvin Henry, is Mr. Henry available as a witness?
Yes. I've spoken with him. The state has him on their witness list. I have good information, contact information for him. The state gave me the contact information that I have.
All right, and Mr. DeQuentis Lamar, who's Rich Homie Quan's stage name, is he available? Is he on?
He's already been subpoenaed. The state filed the subpoena. It came up on whatever we get. We get a copy of the.
What about Rashawn Bennett?
He's unfortunately the most available because he's in your custody, not your custody. He's in the custody of the state of Georgia prison system.
Okay.
So a production order can get him here.
All right, and Brian Birdman Williams?
He's on the state's witness list. I've spoken with him as well. He's available.
Okay, all right.
He's out of state.
Okay.
But he's available. He lives in the state of, I'm not really sure actually. It's either Louisiana, Florida, or I'm not sure. I don't want to speak for where the gentleman is, but he's available.
All right. Okay. Yes, Mr. Steele, thank you.
No, thank you.
Okay.
So I'm going to briefly respond to three specific portions. I heard Mr. Steele say, well, it's a confrontation clause. I believe the court said, well, that's a statement made to Mr. Sprinkle. The statement that we are looking to, Your Honor, is not the statement that Mr. Donovan Thomas Sr. told Mr. Sprinkle. It is what the declarant, who is a deceased individual, spoke to his father. And I want to point the court specifically to Rivers v. State, which is 77 Federal 3rd 1306, which is an 11th Circuit 2015 case. Sure, Rivers v. State, or River v. United States, excuse me, 777 Federal 3rd 1306 at Penn Site 1313.
Okay.
And what that says, Rule 807 analysis must consider whether the statements have guarantees of trustworthiness given the circumstances under which they were made. We examine the trustworthiness of the declarant who originally made the statement, not the trustworthiness of the witness reciting the statement. Okay. So again, we're looking not to what Mr. Donovan Thomas Sr. told Mike Sprinkle, but what did Mr. Donovan Thomas Jr. tell his father? And the reason why Rich Homie Quan, Gervin Henry, and Birdman are not the individuals to speak to that is because they don't have the same relationship that Donovan Thomas Jr. has with his father. And so when we're looking at the case analysis, what you're talking about as far as trustworthiness is what is the relationship between the declarant and the person who's going to come and tell the court or the jury what the statement was. So Rich Homie Quan does not have the same level of a relationship that Mr. Donovan Thomas Jr. had with his father. He spoke to his father every day. He didn't speak to Rich Homie Quan every day. He spoke to his father every day. He didn't speak to Gervin Phi Henry every day. He didn't speak to Birdman every day. So when you're looking at determining the trustworthiness, it is the trustworthiness of who the declarant is speaking to. And specifically, I want to cite to the case that Mr. Steele actually cited in his motion, which is the Hall v. State case, Your Honor. And specifically, on pen side 15 of that particular opinion, there's two cases that the court cites. One is Ash v. State, which says that statements had sufficient guarantees of trustworthiness where the witness and declarant had a close relationship and talked to each other daily. That is the distinction as to why Birdman, Rich Homie Quan, Lucci, and Gervin Fly Henry cannot come in here to speak to the jury about what Donovan Thomas Jr. said to his father. They had a very different relationship, Your Honor. Those individuals could speak about their own relationship during this time with Jeffery Williams. They could speak to their own relationship as it relates to, DeQuancy Lamar can talk about his own feelings about deciding where to go, but he cannot speak to what Donovan Thomas said about what Donovan Thomas thought in his conversation with his father. That I'm sure that the defense would object if we tried to bring in hearsay statements to Rich Homie Quan about Donovan Thomas Jr. And then second, and finally, Your Honor, Mr. Steele just argued that there has been testimony about the beef between YSL and If Gang. That's very general. What we are talking about, again, is very specific, in which Mr. Williams, through his counsel, has asserted that in January 2015, Mr. Williams and Donovan Thomas had a very close relationship or were very friendly. This testimony, we believe, will show opposite of that, that in January 2015, they were not as close as as they have been purporting during their cross-examination of many of the state's witnesses. Sure, Ash v. State.
I'm looking at Hall right now. So
Okay.
All right, y'all give me a few minutes, okay?
Yes.
Just be in recess.
We also have a recording, Your Honor, it's about 8 minutes. And I know this is a synopsis of it, but I think the actual part of the recording actually gives the actual statement. Yes, page 44 and 45, and then the actual recording is about 8 minutes long in discovery. You want to see which one I'm talking about?
Yeah, if you want more version, because my page 44, deals with Tremont Stillwell.
Okay. Is yours 140 pages?
Mine is 100 and... Or 100.
So you look at the one else.
Mine is 162 pages. Search for. Okay. Okay, I see that. I think.
Oh, please, for speaking purposes.
Okay, it's on page 61 for paragraph.
court had an opportunity to consider the state's request to admit state's notice of intent to introduce hearsay evidence pursuant to 24-8-807, filed on May the 23rd of 2024, which I'll include, as I mentioned earlier, as the next court's exhibit in order for purposes of making admissibility determination. The courts also considered Mr. Seal's response, filed, was it filed on the 24th of May?
That's right, sir. Next day.
Okay, and I'll include your email and your Mr. Williams' response in objection, a response in objection to the state's notice of intent to introduce hearsay evidence pursuant to 24-8-807 as the next court exhibit in order. The court will also take judicial notice of the following, that this trial commenced on 4 January of 2023 or thereabouts, and we had motions in this case in December of 2022. I'm also going to consider as the next court's exhibits in order as the court will term it, the Sprinkle Report, pages 44 and 45, pertaining to the inquiry or interview of Mr. Donovan Thomas Sr. by Senior ADA Michael Sprinkle as the next court exhibit in order. In making the determination of whether or not to admit residual hearsay under 24-8-807, the court has listened to the arguments of counsel, and in particular, since our Supreme Court, our Court of Appeals of Georgia has passed on the issue in Hall versus the state decided 15 May 2024, Westlaw 2173621 on the issue of the admissibility of residual hearsay. Under 24-8-807, Rule 807, this is a residual exception to the hearsay, the rule against hearsay. The rule provides a statement not specifically covered by any law, but having equivalent circumstantial guarantees of trustworthiness shall not be excluded by the hearsay rule if the court determines that, one, the statement is offered as evidence of a material fact, two, the statement is more probative on the point for which it's offered than any other evidence which the proponent can procure through reasonable efforts, and three, the general purposes of the rules of evidence in the interest of justice will best be served by admission of the statement into evidence. The statute also goes on to indicate, however, a statement may not be admitted under this code section unless the proponent of it makes known to the adverse party sufficient in advance of the trial or hearing to provide the adverse party with a fair opportunity to prepare to meet it, the proponent's intention to offer the statement and the particulars of it, including the name and address of the declarant. Now, taking a look at the the state's notice of intent. This is what they indicate to the court and their colleagues that they would like to introduce. In pertinent part, and I quote, "Thus, the state intends to offer into evidence statements of the homicide victim, Donovan Thomas Jr., through his father, Donovan Thomas Sr. Donovan Thomas Sr. had a close relationship to his son prior to his untimely death in January of 2015. Donovan Thomas Jr. discussed with his father a potential conflict growing between an individual, DeQuantes, and that's DeQuantes Lamar, Jeffery Williams, and Brian Birdman Williams. Mr. Thomas Sr. will discuss a few conversations in which Mr. Thomas Jr. expressed concern to his father that Mr. Lamar was going to leave his current record label and move to another record label. Mr. Thomas Jr. thought that the new record label was going to take advantage of Mr. Lamar, and he wanted to prevent that from happening. Additionally, Mr. Thomas Sr. will discuss his son distancing himself from Jeffery Williams and Brian Williams during the latter part of 2014. The state has also indicated that they wish to get into several groupings of conversations between Mr. Thomas Sr. and Mr. Thomas Jr., Mr. Thomas Jr. being the decedent. One is his children, and there are several groupings of children that we've heard involving Shell, Kell, and Greedy, and Miss Cave. I'm just using that for purposes of our discussion. I want to make sure that I cover that at least in some pertinent part. The other areas are Donovan Thomas Jr. and Mr. Garvin Henry. Third grouping, Rich Homie Quan. Fourth grouping was Sean Lucci Bennett. Fifth grouping, Jeffrey Williams. Sixth grouping, Brian Birdman Williams. And seventh grouping, the relationship or conversations, two pertinent conversations in the fall of 2014. I want to distinguish that because I have to, for purposes of making a determination that will be potentially reviewed, is that under Rule 807, and I'm quoting from Hall versus the state, Chief Judge Mercier writing, under Rule 807, a trial court's decision to admit hearsay evidence is reviewed for abuse of its discretion. Tanner versus the state, 301 Georgia 852, pinpoint 856. An appellate court should be particularly hesitant to overturn a trial court's admissibility ruling under the residual hearsay exception, absent a definite and firm conviction that the court made a clear error of judgment in the conclusion it reached upon weighing other relevant factors. And the relevant factors are the three factors of that the court entered, I talked about earlier. The statement is offered as evidence of material fact. The statement is more probative on the point on which is offered than any other evidence which the proponent can produce through reasonable efforts. And three, the general purposes of rules of evidence in the interest of justice will best be served by admission of the statement into evidence. And that's Thompson versus the state, 302 Georgia 533. As a general matter, the trial court does not abuse discretion by admitting evidence when the requirements of OCGA 24-8-807 1 through 3 are met, and the trial court concludes that the statements in question have sufficient guarantees of trustworthiness because of the circumstances under which they were originally made. And that's Rawls, RAWLS versus the state, 310 Georgia 209 pinpoint 214 at note 3. Factors to be considered with regard to the admissibility of these statements include a consideration of the trustworthiness of the original declarant, given the circumstances in which they were first made, and whether the guarantees of trustworthiness exist that are equivalent in significance to the specific hearsay exceptions enumerated in Federal Rules of Evidence 803 and 804. Therefore, such guarantees must be equivalent to cross-examined former testimony, statements against statements under a belief of impending death, statements against interest, and statements of personal or family history. And the court cites State versus Holmes, 304 Georgia, 524 pinpoint 529 head note 2. In simpler terms, whether the exceptional guarantees of trustworthiness is a determination that focuses on the declarant and the circumstances under which the declarant made the statement to the witness. Miller versus the state, 303 Georgia, 1 pinpoint 5, I should say subpart 2. Finally, a trial court should consider the totality of the circumstances in determining whether to admit evidence pursuant to OCGA 24-8-807 Reyes, and that's REYES versus the state, 309 Georgia 660 pinpoint 668 note 2. Now in Hall, there were a series of text messages provided information regarding the state of Hall's relationship with Hunt just prior to her death. This information was certainly evidence of material fact, namely the aforementioned relationship, more probative on the point than any other evidence could reasonably be procured, since Hunt was deceased at the time of trial, and the admission of the evidence which gave the context of the alleged crimes served the purposes of the rules of evidence and the interests of justice. And contrary to Hall's main contention on appeal, the trial court did not abuse its discretion by finding these particular texts between Hunt and Ashby contained sufficient guarantees of trustworthiness. Specifically, the court found the text messages were sufficiently trustworthy because the statements were in Hunt's own words, related to the sensitive nature of domestic abuse, and shared under circumstances in which the two women were discovering each other for the first time and discovering they were both seeing the same gentleman. So in this particular circumstance, that's why the court took into account the unique characteristics of the declarant and the circumstances which the statements were made. Ash versus the state, 312 Georgia 771. And this is where the state mentions that statements sufficient guarantees of trustworthiness where the witness and declarant had a close relationship and talked to each other daily. Statements, Jones, 311 Georgia 445 statements had sufficient guarantees of trustworthiness where there was no evidence indicating the declarant had any motive to fabricate her statements. Tanner versus the state, 301 Georgia 852 statements had sufficient guarantees of trustworthiness where the witness and declarant had a close relationship and declarant had no apparent reason to lie, and the statements were consistent with other evidence. In our case, things are a little different, and this is what I'm going to make the distinguishing factors are. Text messages are very distinct. The state's proffer to include the Sprinkle report pages 45 and 46, as well as the state's proffer failed to tell the court and the parties. In fact, Ms. Fulton, the state's representative, indicated that I would probably have to hear testimony on that issue specifically as to what Mr. Thomas Sr. was going to testify to. That doesn't meet the letter and spirit of 24-8-807 in the sense that we don't know. We have groupings of what he may say. We don't know exactly what he's going to say. And that's the first reason. And taking a look at the totality of the circumstances and weighing the other factors, we don't really have what we're asking Mr. Thomas Sr. to recall statements that are 10 years old. He made these statements in 2014. It is 2024. Unlike Hall, where you've got text messages which you can see what the decedent or the declarant was actually saying, we don't have that benefit. And for that reason, that's why these specific tests were reliance or trustworthiness. And the appellate court sets a pretty high bar when they tell the reviewing court, as Mr. Steele mentioned, and also in this particular decision, that I am supposed to look at such guarantees must be equivalent to cross-examined former testimony, statements of a pending belief of a belief of impending death, statements against interest, and statements of a family and statements of personal and family history. That's pretty high in terms of what I have to consider in terms of the admissibility threshold under 807. But in taking a look at Hall, it's very much distinguishing because we had the benefit of looking at what the decedent actually was saying and weighing it in terms of the trustworthiness. In this particular circumstance, the court does not find that it has the same guarantees of trustworthiness. So I'm going to grant the defense's motion to exclude these statements under 807. However, and let me make that very clear. I'm not gonna permit the conversations about the two relationships and the two conversations in the fall of 2014. You can talk about his children. He can certainly clarify the relationships between Marquavious, Greedy, Shellcow, and Sequoia Cove. Certainly those would be probably relevant, but the other ones in terms of Mr. Donovan Thomas, Garvin Henry, Rich Homie Quan, LaShawn Lucci Bennett, Jeffrey Williams, Brian Birdman Williams would not be admissible at this point in time. But however, if you can lay foundation as to the relationship of his children, I certainly think that would be relevant and material. That's not saying, as well as was mentioned earlier, if the state decides to call with the exception of Mr. Jeffery Williams, the other parties in this particular case for their relationships that may or may not be relevant, you certainly may. I'm not in any way telling you cannot call those particular witnesses for other purposes. Mr. Steele, I'll have you, if you would please do a suitable order for my signature, send that to your colleagues from the state, please.
Thank you. Aaron, can I get clarity? Is it just that Mr. Donovan Thomas cannot speak about what his son told him, but he can speak about his own observations? Because hearsay is what someone said. So I want to be clear that Donovan Thomas Sr. cannot speak about what his son told him, but if he has his own personal observation from what he saw.
But you'd have to lay a foundation as to that.
Sure, correct.
But, But I'd say you tread carefully, okay?
I won't have him talk about anything that anyone said, but I believe he can talk about his own personal
He
observations.
certainly can testify about that as long as you lay a predicate and foundation about that.
Sure.
Certainly, that would certainly not be under the realm of impossibilities, okay?
Thank you, Your Honor.
All right, anything else, folks?
Yes, Your Honor, just real briefly on that topic.
No, just no. Okay, stop talking.
30 seconds.
Stop talking. No, what does he want to tell me?
I'll be very brief. I know that the state indicated that they wanted to talk about the family relationship or the children or something of that nature. I'm just a little concerned about how that might impasse the victim impact issue with respect to what's relevant regarding the issues at hand versus background with respect to relationships. So
If they don't talk about the feelings of loss or anything like that, but I think that they want to get into because remember when we were, Ms. Hilton was talking about earlier, we had another witness talk about whose child was who and what that needed. And then that, I mean, they eventually clarified it, but I think that would probably be okay to explain what relationships that, if he can, Mr. Donald Thomas Sr., but as long as he doesn't testify about the loss of his child and violate victim impact, yes, I think that would be appropriate.
thank you, Your Honor.
Okay. Anybody else? Mr. Steele, have I ruled completely on your motion? Okay. All right, sir, if you could just have a written response within about a week, is that fine? Okay. All right. Any clarifications as to what you can and cannot talk about in regards to Mr. Thomas Sr.?
My understanding, he can't talk about what anybody else said.
That's right. And he can't talk about what conversations he had with his son. Okay, but
Correct.
he can testify about what his observations were. He can certainly testify about what the relationships with his children. Okay, but these other folks, you know, that would be.
But he can talk about his observation that he's seen with these other people.
If you can lay a foundation.
Yes, I believe.
For example, if he doesn't know or he doesn't have any, for example, conversations about Donald Thomas, and then you got to really think about why are you asking about that? Because it may get you into hot water. So I'm just telling you, just tread lightly, okay?
Thank you, Your Honor.
Okay, folks, unless you have anything else at this point in time, thank you for your patience, and we will see you all tomorrow morning, 9:30 for an anticipated 10 o'clock start time, all right? Okay, we're in recess. All right.